Veuillez vous asseoir.
Please be seated.
L'audience est...
The sitting is open. For reasons duly made known to me, Judge Yusuf is unable to sit with us today. The court meets this afternoon to hear the second round of oral argument of the Republic of Armenia on the preliminary objections raised by it in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. I shall now give the floor to Mr. Lawrence Martin.
Mr. President, distinguished members of the Court, good afternoon. As I did on Monday, I will address Armenia's preliminary objection concerning the scope of the Court's jurisdiction, ratione temporis. I will focus only on certain key points. The first such one is a general point that touches on all the speeches we heard yesterday, very much including, but not limited to, Professor Lowe's intervention on jurisdiction ratione temporis. In what was clearly a coordinated effort, all of yesterday's speakers made repeated reference to a so-called ethnic cleansing campaign that was said to be ongoing even now, 30 years since the end of the First Nagorno-Karabakh War. Professor Lowe said, for example, quote, "The ongoing and systematic nature of Armenia's campaign of ethnic cleansing, spanning 3 decades, can in no sense be considered to have been completed before September 1996. All of his colleagues got in on the action too. Even the questions of landmines and the environment were said to be elements of this so-called campaign. The purpose of this coordinated effort was undoubtedly to make it seem that the issue of the critical date in this case is unimportant, because what happened more than 3 decades ago is all bound up together with what is still happening now in a single package encompassing the entire period. Our friend's effort, however, is seriously misguided. There can be no doubt on this matter. As I said on Monday, Armenia roundly rejects Azerbaijan's ethnic cleansing accusations. But that is not the point now. What matters now is that even on Azerbaijan's own factual allegations, any alleged ethnic cleansing was completed by 1994, well before the critical date, it's September 1996. On Monday, I observed that Azerbaijan had not provided a definition of ethnic cleansing. Yesterday, Professor Lowe obliged by providing one. It is, he said, quote, "a purposeful policy designed by one ethnic or religious group to remove, by violent or terror-inspiring means, the civilian population of another ethnic or religious group from a certain geographic area." To remove the civilian population from a geographic area. This, of course, is just a different formulation of the Court's definition from the Bosnia case. Both come from the UN Commission on the former Yugoslavia, and under both definitions, the point is that once the civilian population of an area has been removed, once everyone is left, the ethnic cleansing is over. To be sure, the effects may continue afterwards, but the act is completed. The Court should not be tempted by Azerbaijan's transparent ploy of relabeling what are obviously subsequent, discrete events as part of this supposedly continuing campaign of ethnic cleansing. The acts alleged by Azerbaijan may or may not constitute discrete breaches of the CERD, but they are certainly not part of a purported wrong that took place and ended 30 years ago. Turning then more specifically to the question of the Court's jurisdiction ratione temporis. On Monday, I discussed how the only sensible interpretation of Article 22 is that it should be temporally limited to acts and facts that occurred at a time when the parties to a dispute are both parties to a convention. In other words, when the convention is in force between them. To find otherwise risks creating serious irregularities that the drafters of the CERD cannot have intended. Could the drafters really have intended that states that only later accepted their obligations under the convention should somehow acquire a procedural advantage over states that accepted those same obligations at an earlier moment in time? Professor Lowe notably had nothing to say about the absurdity of such an approach. As we also explained on Monday, allowing Azerbaijan to raise claims relating to the pre-96 period would raise serious retroactivity issues. Yesterday, Professor Lowe responded confidently that, quote, there is no question of retroactivity in the present case because the relevant conduct underpinning Azerbaijan's claims of breach occurred after CERD's entry into force for Armenia in 1993. With respect, this misconstrues the nature of the problem. This is not the retroactivity issue we are talking about. The retroactivity issue here is that Azerbaijan is trying to use Article 22 to reach back in time and claim the right to raise questions about Armenia's compliance with its obligations under the CERD in relation to a period of time when Armenia did not owe those obligations to Azerbaijan. In our view, Article 22 simply cannot be used that way. The character of the CERD's substantive obligations only underscores the impermissibility of what Azerbaijan is trying to do. Yesterday, for the first time, Azerbaijan acknowledged that the substantive obligations at issue in this case are not obligations erga omnes, but obligations erga omnes partes. These obligations, sometimes also referred to as obligations erga omnes contractantes, are owed by states to a treaty to the other states' parties. In his remarks yesterday, Professor Lowe appeared to agree. He said, the erga omnes partes and Hughes Kogan's character of the obligations under the CERD and similar treaties supports the principle that those obligations are engaged for every party from the date that the treaty comes into force for that party. The court's reasoning in Belgium v. Senegal is again on point. Obligations in conventions such as the Convention Against Torture, in that case, or the CERD, in the present case, are owed to all states' parties, and any state party can call out those who break the commitment. This is fine, so far as it goes. The issue lies in what Professor Lowe does not say. Obligation erga omnes partes are indeed owed to all states' parties. They are not, however, owed to non-states' parties. Thus, from July 1993 to September 1996, Armenia owed its obligations erga omnes partes to those 140 or so state parties that were in effect partes to the CERD at the time. But because Azerbaijan was not then a party to the convention, Armenia did not owe it any obligations erga omnes partes. As from the entry into force of CERD for Azerbaijan in 1996, Armenia and Azerbaijan owed each other procedural rights under Article 22. But the creation of that procedural right did not transform the character of the substantive obligations that Armenia owed under the convention prior to that date. Armenia's obligations from 1993 to 1996 remain as they were before Azerbaijan became a party to the convention. That is to say, they were owed to all of the states then parties to the CERD. Azerbaijan's ratification of the CERD 3 years later did not expand retroactively the pool of states to whom Armenia owed the substantive obligations under the CERD before that date. To argue otherwise distorts basic logic in the principle of intertemporal law. The fact that erga omnes partes obligations are owed only to states that are actually partes is reflected in the language the court used in Belgium v. Senegal. As you can see on the screen, the court stated that, quote, these obligations may be defined as obligations erga omnes partes in the sense that each state party has an interest in compliance with them in any given case. Support for all this can also be found in the resolution of the Institut de droit international on obligations and rights erga omnes in international law, for which Judge Gaia was rapporteur. You can find that resolution at tab 2 of your judge's folder. As you can see, the resolution addresses both obligations erga omnes and obligations erga omnes partes. The latter are defined in paragraph B of the first article as, quote, an obligation under a multilateral treaty that a state party to the treaty owes in any given case to all the other state parties to the same treaty in view of their common values and concern for compliance, so that a breach of that obligation enables all these states to take action. In other words, the obligation is owed to a group of states, such that a breach of that obligation enables all those same states to take action. Such a breach, of course, occurs at a specific moment in time, and that moment in time defines the states to which the obligation is owed and for which the breach creates a cause of action. This comes through unmistakably in the next article in the resolution, which states, quote, when a state commits a breach of an obligation erga omnes, all the states to which the obligation is owed are entitled to claim. Professor Lowe stated yesterday that, quote, it is not a matter of the standing of particular states. But that is precisely what it is. Article 3 of the resolution states, in the event of there being a jurisdictional link between a state alleged to have committed a breach of an obligation erga omnes and a state to which the obligation is owed, the latter state has standing to bring a claim before the International Court of Justice. Little more need be said. The extent of the erga omnes partes obligation is assessed at the time of the putative breach. It is owed to the states then party to the multilateral treaty containing the obligation. When there is a jurisdictional link, those states and only those states have standing to claim for that breach. The obligation itself, the identity of the states to which it is owed, and the standing of those states does not change retroactively when other states adhere to the convention years or decades later. Much the same point can be made using a different lens. Yesterday, Professor Lowe took you to Article 28 of the Vienna Convention on the Law of the Treaties. It's worth looking at. Again, it's on the screen before you. It says, if I may paraphrase, the provisions of a treaty do not bind a party in relation to any act or fact which took place before entry into force of the treaty with respect to that party. That, of course, makes perfect sense. But there's a corollary. Treaty rights and obligations are a package deal. And in our case, if a state has no obligations with respect to any fact or act which took place before the treaty enters into force for it, neither can it have any rights with respect to such acts or facts. That means that Azerbaijan should not be permitted to use the right it acquired to access ICJ jurisdiction under Article 22 of the CERT in 1996 to raise complaints in relation to acts or facts which allegedly took place before that date. They are, in short, outside the scope of the court's jurisdiction, ratione temporis. I explained Monday that Azerbaijan cannot save its claims relating to the pre-96 period by relying on a theory of composite breach. Yesterday, Azerbaijan appeared to change its position. Professor Lowe said yesterday that, quote, the relevant contrast here is not between completed acts and composite acts, but between completed acts and continuing acts. Assuming that this is indeed now Azerbaijan's primary theory, it too is insufficient to save Azerbaijan's case insofar as it relates to acts and facts alleged to have occurred in the pre-96 period. Armenia, of course, does not dispute that an act can be continuing and can start before the critical date and continue thereafter. But that fact is of no assistance to Azerbaijan. The ILC commentary to the draft articles on state responsibility makes clear that when an act continues in such a way as to straddle the critical date, the elements of the act that occurred before the critical date are outside a court or tribunal's jurisdiction. Only the elements that occurred after the critical date come within the jurisdiction ratione temporis. I refer you in particular to paragraphs 9 through 11 of the ILC's commentary to Article 14 of the draft articles. Professor Lowe also offered a curious new theory that, quote, composite acts are just one kind of continuing act. He reminded us that, quote, a composite act extends over the entire period, starting with the first of the actions or omissions of the series, and lasts for as long as these actions or omissions are repeated and remain not in conformity with the international obligation. But both of these no theories fail for the reason I already addressed at the outset. In concluding his discussion of Azerbaijan's theory of continuing breaches, Professor Lowe stated, quote, Azerbaijan says that Armenia's cumulative or aggregated acts and omissions amount to a practice of ethnic cleansing which, like apartheid, is itself a distinct breach of the CERD. He then stated the definition of ethnic cleansing I quoted earlier. This argument fails because, as I said, even on Azerbaijan's own case, the alleged expulsion of civilians, which Armenia denies, was complete no later than May 1994, the date of the ceasefire ending the First Nagorno-Karabakh War. Whatever may have happened thereafter was conduct of a different character that cannot genuinely be characterized as a continuing act, nor can it be a continuing composite breach spanning the critical date for the same reason. Professor Lowe asked yesterday why Armenia has not yet raised counterclaims in this case. Well, the answer is simple. It's found in Article 80, paragraph 2 of the Rules of Court, which states that counterclaims shall be made in the counter-memorial. Lest there be any doubt, if the court upholds Azerbaijan's theory that the displacement of populations before the critical date can be swept into the court's jurisdiction by virtue of other acts of racial discrimination after the critical date, Armenia will have no shortage of claims to bring. Mr. President, distinguished members of the court, two other quick points about a couple of cases Professor Lowe cited. First, the Bosnia genocide case. Yesterday, he argued that Armenia is in the same position as Yugoslavia in that case, and that in response to Yugoslavia's objection, ratione temporis, the court established a general rule that compromissory clauses under multilateral treaties grant jurisdiction over, quote, facts which occurred prior to the convention entering into force between the parties. But that 1996 judgment does not, in fact, establish any such clear-cut rule. Azerbaijan hangs a lot of its case on a single sentence in which the court, quote, confines itself to the observation in question. There is no analysis establishing a general principle that can be applied neatly to all situations. And as I mentioned on Monday, and Azerbaijan ignored, the same issue continues to be the subject of debate by parties before the court. Belgium v. Senegal is instructive. Members of the court may recall that Judge Donoghue posed pointed questions on this issue from the bench, and that Belgium then took care to formulate its claims in such a way that would avoid retroactive application of the compromissory clause. I also mentioned on Monday several layers of complicating and distinguishing factors from Bosnia, including the fact that both states were successors to the Convention, there were contested issues of recognition, and there was temporal equality between the parties. Azerbaijan had nothing to say about any of that. Professor Lowe also curiously cited the court's 2012 judgment in the first Nicaragua v. Colombia case for the proposition that, quote, Colombia was entitled to invoke obligations of Nicaragua as a state party to UNCLOS, even though Colombia itself had never become a party to the UNCLOS. Now, I know that Professor Lowe and I both have a fondness for that case, but I confess I don't understand what use he's trying to make of it. All the court said in that case is the fact that Colombia was not a party to UNCLOS did not relieve Nicaragua of its obligation under the Convention to submit its claim to a continental shelf beyond 200 nautical miles to the CLCS. And that, Mr. President, brings me to my final point. Armenia's objections concerning jurisdiction Rationale Temporis have an exclusively preliminary character and are ripe for determination now. Yesterday, Professor Lowe seemed to invite you to join the objections to the merits, suggesting they may not have an exclusively preliminary character. He's mistaken. The first issue on which we request a ruling, that concerning the critical date, could not be a pure question of law. There is no reason it cannot be decided now, and Azerbaijan has not pointed to any. The second issue, whether Azerbaijan's pre-96 claims can be saved by the assertion that they constitute part of a so-called continuing campaign of ethnic cleansing, is equally ripe for determination at this stage. The parties agree on the definition of ethnic cleansing, and there is no allegation that any Azerbaijani population was removed or displaced after 1994. There is therefore no impediment to deciding the issue as a preliminary matter. Mr. President, distinguished members of the Court, thank you again for allowing me the privilege of appearing before you. Would you kindly invite Professor Darjan to the podium?
I thank Mr. Martin for his statement. And
I now invite Professor Pierre Darjan to address the Court. Mr. President, members of the Court, I shall respond to Professor Tallman regarding the inadmissibility of Azerbaijan's claims, and by first noting that both parties agree on the applicable legal test in this regard, that is to say, the test that emerges from the Court's jurisprudence in the Nauru case and the work of the ILC. In light of the ILC's proceedings, Azerbaijan maintains that a disadvantage from a belated claim for a respondent exists, but only if it could reasonably have been expected that the claim would no longer be pursued. Thus, Azerbaijan accepts that a respondent has necessarily been placed at a disadvantage by the belated bringing of a claim if it is determined that it might reasonably have been expected that that claim would not be pursued. And given that that is the legal test, three questions which the Court needs to decide on three questions at this point in time, and I'd like to analyse those. The first question is whether, and if so, when Azerbaijan presented a claim, strictly speaking, presented it to Armenia. And the second question is whether the time that has passed or that had passed between the events with which the claim is concerned and the bringing of the claim was such that implied to Armenia that the matter would not be the subject of contentious proceedings and that the claim should therefore be considered out of time and inadmissible for that reason.
And that the third question is whether there are circumstances which might excuse the applicant's delay in filing its claim. Now, regarding the first question, Armenia considers that Azerbaijan did not present a legal claim pursuant to the Convention concerning the events of the First Nagorno-Karabakh War to it prior to the 8th of December 2020. In contrast, Azerbaijan asserts that it informed Armenia of its grievances on a number of occasions. First of all, I note that Azerbaijan has not contested what I said regarding its letter of the 8th of December 2020 and the documents referred to it in its written submissions, which were analysed before you on Monday. Professor Talman inserted, as a note in his pleadings, a series of documents provided to the United Nations between 1993 and 1997, in which it is alleged that its citizens had been the victims of ethnic cleansing during the First War. Now, I have 2 points on this point. First of all, the grievances set out in these documents concerned ethnic cleansing, which allegedly had taken place and had already been completed in 1994. Those documents in no way refer to ethnic cleansing continuing beyond that point in time. And members of the court, this confirms that the way in which Azerbaijan has framed its claim before the court is artificial and purely opportunistic. Ethnic cleansing continuing over the course of 30 years was invented starting in December 2020, and that in response to Armenia's claims in order to overcome obvious obstacles in terms of jurisdiction, both material and temporal. Second point, Armenia does not contest that it has faced grievances from Azerbaijan. That's not the issue. When it comes to an objection of inadmissibility based on delay in filing a claim, the issue is whether Azerbaijan's grievances constitute a legal claim. Professor Talman asserted that it was sufficient that, and I quote, the grievances raised relate to the subject matter of the treaty, end of quotation, and that it was of little importance whether the convention itself had been mentioned. Now, the case law referred to by Professor Talman concerns the emergence of a conflict, of a dispute, and not the framing of a legal claim. Thus, before considering whether the convention was hidden behind Azerbaijan's grievances, the key question is whether, before the 8th of December 2020, Azerbaijan presented to Armenia any legal claim as such. In other words, a claim setting out a legal claim based on invocation of the international responsibility of the Republic of Armenia and not the legal or moral responsibility of the leaders of that country. Members of the court, every day dozens of states make complaints, criticisms, level allegations against one another. In other words, grievances, and unfortunately ad personam accusations are ever the more prevalent. But for these grievances to count with respect to the principles pertaining to contentious proceedings concerning the admissibility of late-filed claims, they must constitute a legal claim, strictly speaking. That was the case in the Nauru case, where the applicant had set out a legal claim in terms of international responsibility on 4 occasions. Then the issue was whether the applicant might expect, after a certain period of time, that the claim would no longer be pursued. So it's not enough to just present a factual situation, nor even that a characterization recognized by law be used to summarize or to decry the factual situation. No, more fundamentally, a legal claim must be framed. In the absence of such a legal claim, in the absence of invocation of the responsibility of a state, there may be a dispute, but there is no legal claim, strictly speaking. And that is what I pointed out, I pointed out on Monday, underlined that Armenia had a reasonable expectation that no claim pursuant to the Convention would be made or indeed pursued. Prior to the 8th of December 2020, no legal claim invoking the international responsibility of Armenia with respect to the events of the first war had been presented by Azerbaijan. Therefore, there certainly cannot have been a repetition of a claim because no claim had been made. Armenia considers that the delay taken by Azerbaijan in this connection is prejudicial to it because it had a reasonable expectation that no claim would be presented. Now I will address the second question. Even if these grievances communicated by letters to the United Nations could have been considered to be legal claims, Armenia reasonably could have felt that the claim would not be pursued by legal means more than 23 years later, not least given that the most recent letter from Azerbaijan was dated the 25th of October 1997. The first reason is that the convention was not enforced between the parties at the time of the first war. Even prior to 1996, the grievances must have had a legal basis other than the convention. And the second reason follows on from that legal reality and is essential. It is that since the 1994 ceasefire and mediation under the auspices of the OSCE, Azerbaijan has undertaken to resolve the consequences of the first war by negotiation and has solemnly reiterated that commitment by becoming member of the Council of Europe. Azerbaijan violated that commitment 20 years later by launching the second war in September 2020. And so, Azerbaijan never gave any indication throughout that long period that its grievances would become the subject of a legal claim pursuant to the convention and invoking international responsibility. On the contrary, given that the second war, according to President Aliyev, brought to an end the diplomatic process and that it constituted the height of discriminatory practices by Azerbaijan, as well as new violations of the convention, Azerbaijan framed its legal claim and invited Armenia formulated its legal claim and invited Azerbaijan to negotiate pursuant to Article 22, and that immediately after the trilateral statement. Professor Talman is guilty of a false equivalency when he reuses the terminology, what is sauce for the goose is sauce for the gander. That is, in fact, inappropriate. Now I will address the third question and whether there are any reasons to excuse Azerbaijan for presenting its legal claim pursuant to the convention only after having obtained access to Nagorno-Karabakh. According to Professor Talman, Armenia claims that, and I quote, a reasonable expectation was created because Azerbaijan allegedly had all the material to bring a claim upon its accession to the convention in 1996, but did not do so. End of quotation. But what I argued on Monday is, in fact, different and much simpler. And that is that Azerbaijan had, well before 2020, all of the evidence needed to make a legal claim pursuant to the convention, and therefore it is no excuse that it did not have access to Nagorno-Karabakh. Why? Because the claim concerns, and the agent reconfirmed it, the claim concerns a 30-year campaign of ethnic cleansing. But if Azerbaijan's claim relates to a campaign and not specific facts or specific events, it is difficult to see how access to the territory to collect particular evidence was necessary. The excuse of being unable to access the area is not a real excuse, and the allegation of a ethnic cleansing campaign lasting 30 years is being presented simply to bolster its dossier with claims relating to mines and the environment and this to circumvent issues regarding the material and temporal competence or jurisdiction of this court. I now turn to the matter of the disadvantaged Armenia. Professor Talman uses actori incumbit probatio as a shield to argue that Azerbaijan's extreme delay is not prejudicial to Armenia at all. This ignores the fact that Armenia has the right to defend itself, including by presenting evidence. Professor Talman argues that Armenia has had 26 years to collect evidence in its defense, plus 2 further years between 2020 and 2023. This ignores the fact that, according to a legal principle that it accepts itself, the disadvantage exists when a respondent, and I quote, could reasonably have expected that the claim would not be pursued. And I would add, given that that is the case here, or would no longer be made. For over the course of 26 years, Azerbaijan did not frame any legal claim, did not give the impression that it would formulate such a claim or that it would pursue it. Despite this, Armenia was supposed to be preparing its defense. One here forgets the fact that during that period between the 8th of December 2020, that is, say, the final attack of September 2023, the Lachin corridor was controlled by the Russian contingency. And it was finally blocked for 9 months by Azerbaijan. All of these facts relate to the possibility to present or to gather evidence in support of a case. Now, as regards the procedural inequality, which was addressed on Monday with respect to the counterclaims, I note that Professor Talman confirmed that this problem did exist, but that that was a normal thing, it being a consequence of the rules of court, which we knew, and being the consequence of obligations deriving from treaties, which arise once those treaties are accepted, which we also knew. Despite the fact that it could have framed counterclaims in another case, Azerbaijan is perfectly clear about its procedural tactic in this case and does not deny it at all, and that the result is one-way historic justice. It would be astonishing if the court did not see an issue in that. Mr. President, members of the court, I thank you for your attention over the last 2 weeks, and I would invite you, Mr. President, to invite Mr. Salamandis to the bar to address the court. President, I thank Mr. D'Argent for his intervention, and I would now invite Mr. Konstantinos Salinidis to take the floor. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the court, I will be responding today to the points raised by Mr. Wadsworth and Mr. Orhi yesterday concerning Armenia's preliminary objection with respect to Azerbaijan's claims and contentions concerning landmines and booby traps. I begin with my first point, which concerns the proper characterization of Azerbaijan's claims and contentions. Mr. Wadsworth yesterday insisted that Azerbaijan is not alleging a freestanding claim of breach of the CERD in relation to landmines and booby traps. In support of this position, Mr. Wadsworth pointed to the Court's December 2021 order, where the Court stated, I quote, Azerbaijan claims that this conduct, that is, Armenia's alleged placement of landmines, is part of a long-standing campaign of ethnic cleansing. Our response is that this statement by the Court in no way undermines its powers to interpret for itself the submissions of the parties and to identify what Azerbaijan is claiming on an objective basis, powers that Mr. Wadsworth did not contest yesterday. Mr. Wadsworth also did not address the abundance of evidence that I pointed to on Monday. In Azerbaijan's application, in Azerbaijan's first request for provisional measures, and at the hearing on that request, in Azerbaijan's second request for provisional measures, and at the hearing on that request, and in Azerbaijan's memorial, all showing that Azerbaijan does, in fact, allege that Armenia's alleged laying of landmines and booby traps violates the CERD. Instead, Mr. Wadsworth jumps straight to the submissions at the end of Azerbaijan's memorial and noted that they do not expressly isolate the alleged placement of landmines and booby traps as an independent violation of the CERD. But the Court is by no means bound by the framing adopted by the applicant in its submissions. Otherwise, as the Court has held in another context, parties would be in position themselves to control the Court's competence, which would be inadmissible. That is, if Azerbaijan were correct that the Court must defer to its framing of its claims in the submissions, then Azerbaijan could throw any and all allegations, even those entirely unrelated to racial discrimination, into its bucket of ethnic cleansing, without giving Armenia any chance to exclude them from the Court's consideration at the preliminary objections stage. This cannot be correct. This brings me to my second point, which is that even if Azerbaijan were correct that its claims and contentions in relation to landmines and booby traps are only a subdivision, to use Mr. Wadsworth's term, of its overarching claim of ethnic cleansing, the Court may still uphold Armenia's preliminary objection with respect to this so-called subdivision. In certain Iranian assets, for example, Iran, in the submissions of its memorial, asserted the United States had breached its obligations under many provisions of the bilateral Treaty of Amity by allegedly engaging in a wide variety of conduct. In response, the United States observed, I quote, "Under almost every article of the treaty Iran invokes, Iran complains that rules of state immunity have been disregarded." And the United States filed a preliminary objection asking the Court to dismiss, I quote again, "as outside the Court's jurisdiction all claims brought under any provision of the Treaty of Amity that are predicated on the United States' purported failure to accord sovereign immunity to the government of Iran, Bank Markazi, or Iranian state-owned entities," end quote. The Court upheld the objection, thereby dismissing at the preliminary objection stage the subdivision of each of Iran's claims predicated on its sovereign immunity contention. Another example of the Court upholding a preliminary objection with respect to a subdivision of a claim may be found in the Diallo case. There, Guinea, in the submissions of its memorial, stated as a single claim that the DRC was responsible for, among other things, not respecting Mr. Diallo's rights under the Vienna Convention on Consular Relations, mistreating him, and depriving him of his rights of ownership and management over his companies. At the preliminary objection stage, the Court upheld the DRC's objection regarding Guinea's lack of standing, but only insofar as it concerns protection of Mr. Diallo in respect of alleged violations of rights of his companies. This again was a dismissal of a subdivision of a claim. In summary, regardless of whether the Court exercises its power to characterize Azerbaijan's claims or not, it has the power to uphold Armenia's jurisdiction ratione materia with respect to Azerbaijan's claims and contentions concerning the alleged placement of landmines and booby traps. My third point relates to Mr. Wadsworth's remarks regarding the relevance of the Court's finding of implausibility at the provisional measures stage. Mr. Wadsworth yesterday, unsurprisingly, sought to rely on the Court's decision in the Ukraine versus Russia case with respect to claims under the International Convention for the Suppression of the Financing of Terrorism. There, the Court found, at the provisional measure stage, that the presence of the requisite elements of intention and knowledge was not plausible. But then, at the preliminary objection stage, the Court considered that ascertaining these elements was properly a matter for the merits. The Court in that case did not, however, say that a finding of implausibility at the provisional measure stage is never relevant for ascertaining its jurisdiction ratione materia at the preliminary objection stage. Mr. Wadsworth gave the impression otherwise by quoting from paragraph 58 of the court's judgment in that case, where the court stated, at the present stage of the proceedings, an examination by the court of the alleged wrongful acts or of the plausibility of the claims is not generally warranted. But aside from the fact that the court was careful to not state an absolute exclusion, there the court was speaking of the plausibility of claims, not the plausibility of rights. Only the latter is determined by the court at the provisional measure stage. If the rights invoked by the applicant under the treaty are not even plausible, then there is serious doubt indeed as to where the court has jurisdiction, ratione materiae, over the claims based on those very rights. At the end of the day, the court has already twice found that the alleged rights asserted by Azerbaijan with respect to landmines and booby traps are not plausible. The measures of which Azerbaijan complains, that is the placement of landmines and booby traps, are therefore not capable of having an adverse effect on rights protected under the CERD, such that the court does not have jurisdiction on ratione materiae with respect to those measures. The court should feel comforted in this conclusion, considering the evidence Azerbaijan has sought to rely on, to which I now turn. Mr. Ohi's presentation yesterday morning was the first time that Azerbaijan attempted an evidentiary showing at this stage of the proceedings, and we welcome the opportunity to remind the court why Azerbaijan's claims are not capable of falling under the CERD. Mr. Ohi argued yesterday that Azerbaijan has put forward more than sufficient evidence showing two things. First, that what he calls Armenia's forces, quote, placed landmines and booby traps in civilian areas far from the line of contact. And second, that Armenia, quote, continued to refuse to share complete and accurate information on the location of the minefields and booby traps, long after the cessation of hostilities. I'll address the 2 points in turn by focusing on the evidence Mr. Ohi relied on in his presentation. First, the argument on the alleged placement of mines and booby traps. For the sake of argument, I will accept that it was Armenia's armed forces that planted mines, and not Azerbaijan's or Nagorno-Karabakh's armed forces. I will also accept that it was Armenia's armed forces that planted booby traps, and not Nagorno-Karabakh's armed forces or persons with military experience who were being forced to leave their homes. I will further accept that mines and booby traps existed where Azerbaijan says they did. For the avoidance of any doubt, Armenia does not accept any of these points, but we recognize that they belong to the merits. I will, however, test Mr. Ohi's assertion that the evidence shows on its face that the alleged conduct, quote, has had no defensive purpose. And I will do that by starting with Azerbaijan's update to Figure 3 of Annex 22 of its additional annexes for the hearing on its request for provisional measures of 31st January 2023, which Azerbaijan submitted to the court a couple of days ago. Let us look at this map, which is now on your screens. Yesterday, Mr. Ohi made much of this map for the point that the locations where mines have exploded were not confined to the line of contact. This may be taken as true in the current phase of the proceedings, but it does not prove in and of itself that Azerbaijan's claims are capable of falling under the CERD for the reason I will explain shortly. The next slides will show to the court the progression of Azerbaijani forces during the Second Nagorno-Karabakh War and the consequent retreat of the Armenian forces. The first slide shows the situation that prevailed on 27 September 2020, just before the outbreak of the Second Nagorno-Karabakh War. The area shaded in red represents the areas under Nagorno-Karabakh's control. Then, on 10th October 2020, you can start seeing in blue the advancement of Azerbaijani forces into the territory. Finally, at the end of the war, a month later, on 10th November 2020, you can see most of the area now in blue and under Azerbaijan's control. Now, let us compare the map on your screens to the one Mr. Ohi showed you yesterday. I kindly ask the Court to focus its attention on the bottom half of the map, depicting locations where mines have reportedly exploded away from the line of contact. As you can see, they match very closely the areas that were progressively falling under Azerbaijan's control, as our ethnic Armenian defense lines were collapsing and Armenian forces were retreating in haste. Armenian forces retreated across the very area where you can see the red dots depicting minefields. Those minefields would have protected the armed forces retreating from the advancing army. Now, let us focus on the red dots depicting minefields on the top half of the map. The next slide shows the situation prevailing on the ground just before Azerbaijan's most recent aggression on Nagorno-Karabakh as of 19 September 2023. Again, the area shaded in red is the one remaining under Nagorno-Karabakh's control, and the one shaded in blue is the one which fell under Azerbaijan's control pursuant to the trilateral statement. I should pause here to note that the trilateral statement did not diffuse the military situation in Nagorno-Karabakh, as there were repeated violations of the ceasefire, notwithstanding the presence of the Russian peacekeeping forces. The next slide shows the situation prevailing after 20 September 2023, with the entire Nagorno-Karabakh region now under Azerbaijan's control. Now, let us compare the map on the eve of last September's attack with the one Mr. Ohi showed you yesterday. As you can see on your screens now, the red areas to which ethnic Armenians retreated pursuant to the trilateral statement also very closely match the remaining red dots on Azerbaijan's updated map. And what of the remaining sporadic dots to the left side of the map? These are remnants of the first Nagorno-Karabakh war per Azerbaijan's own evidence, which I list in footnote. Mr. President, members of the Court, I need not belabor a point which should be obvious to everyone in this room. This comparison, based on Azerbaijan's own evidence and objective facts, should be sufficient to show that any landmines, new or old, were placed there for defensive purposes only, including during the retreat of military forces. Landmines planted to obstruct the progress of the enemy and protect the retreat of armed forces cannot possibly amount to racial discrimination. Mr. Ohi cited to a number of other documents which on their face similarly do not establish the Court's jurisdiction ratione materia over Azerbaijan's claim. Annexes 32 and 36 to Azerbaijan's first request for provisional measures were thoroughly addressed by Professor Murphy at the first hearing on provisional measures, and the relevant references are included in footnote. The Court examined this evidence in its order on Azerbaijan's first request, holding that it failed to indicate that Armenia's alleged conduct constituted racial discrimination. You were also shown some photos from Azerbaijan's Annex 10 and heard some references to Azerbaijan's Annex 24, this time to the second request for provisional measures regarding booby traps. Those two were thoroughly addressed by Professor Murphy at the second hearing on provisional measures, and the relevant references are included in footnote. The Court examined the evidence already when reaffirming its conclusion that Azerbaijan's allegations relating to booby traps were as implausible as those relating to landmines. You also heard a reference to a December 2020 UN Interagency Mine Action Assessment in a letter Azerbaijan sent to the United Nations Secretary General. It is quite telling that the best quote from that assessment Azerbaijan was able to muster in its letter refers to indications that some houses might have been booby-trapped. And here is the important part, as the Armenians withdrew. It is pure despair to bring this forward as important evidence, and yet this is what Azerbaijan did yesterday. What remains? A report issued by an international organization of which Armenia is not a member and prepared solely on the basis of Azerbaijan's allegations, and two statements by Azerbaijan's Mine Action Agency issued after the scheduling of this hearing. None of these documents add anything to the evidence that the court has already thoroughly examined twice, nor does it detract from the reality of the situation, which is that landmines and booby traps were planted for defensive purposes, including during the withdrawal of armed forces. I now turn to Mr. Ohi's second point, that Armenia's, I quote, continued refusal to share complete and accurate information on the location of the minefields and booby traps long after the cessation of hostilities can have had no defensive purpose. For the sake of argument, I will again accept that Armenia has withheld information on the location of landmines and booby traps. For the avoidance of any doubt, however, Armenia strongly rejects any such allegation. I will, however, venture to answer Mr. Ohi's question yesterday as to, I quote, what possible justification would there be for Armenia not to hand over comprehensive and accurate information as to the placement of landmines and booby traps after November 2020? Well, there are many possible justifications, and none of them is because Armenia allegedly racially discriminated against Azerbaijanis. One justification may be, for example, that information was not simply at Armenia's disposal, and it became available only after Armenia received the forcibly displaced from Nagorno-Karabakh. In fact, the document Mr. Ohi relied on yesterday shows precisely that, when noting that, I quote, the transferred maps were received through Nagorno-Karabakh military personnel. Or maybe the answer to Mr. Ohi's rhetorical question is even simpler than that. Tens of thousands of ethnic Armenians still lived in Nagorno-Karabakh after the conclusion of the Second Nagorno-Karabakh War. Maybe the landmines were used precisely for the reason they are intended to be used the world over, as a means to defend military positions. Maybe handing over maps would have compromised the security of the ethnic Armenian population. And the constant deadly violations of the ceasefire Azerbaijan purported to agree to under the trilateral statement, as well as the events of last September, prove that any such concern would have been well-founded. In short, Mr. President and members of the Court, the evidence before the Court, on its face, does not show that Armenia has laid mines and booby traps or withheld maps for any purpose or effect relating to racial discrimination, let alone as a part of a 30-year-long campaign of ethnic cleansing. As such, Azerbaijan has not shown good reason why the Court should treat its claims any different than it did in its two requests for provisional measures. The Court does not have jurisdiction ratione materia with respect to those claims, and Armenia respectfully asks you that you reject them in limine at this phase of the proceedings. This brings my presentation to an end, Mr. President, and I would kindly ask you to call upon Ms. MacDonald to continue Armenia's submissions.
I thank Mr. Saronidis for his statement. I now invite Ms. Alison MacDonald to take the floor. You have the floor, Madam.
Mr. President, Madam Vice President, members of the Court, I will respond to Azerbaijan's oral submissions on its claims of environmental harm. Starting with the legal framework, Professor Boisson de Chazouren cited the twofold test applied by the court in the first Ukraine versus Russia case. The court will recall that Armenia also cited this passage on Monday, along with the paragraph which followed it, which I showed you on the screen and which we have here. So it's not quite clear to us why Professor Boisson de Chazourne said yesterday that Armenia has sought to argue something else. Be that as it may, remaining with the legal framework a moment longer, on Monday I set out 3 propositions derived from the court's case law. First, the showing of disparate effects must still be directed at establishing that the conduct complained of was based on a prohibited ground. Second, the showing of a disparate effect will not suffice if there's an objective and reasonable explanation for the disparity that does not relate to the prohibited grounds. And thirdly, mere collateral or secondary effects on a particular group are not enough. And I showed you on Monday that this was expressly accepted by Azerbaijan in its submissions last week. These propositions were not mentioned, let alone disputed, by Professor Boisson de Chazourne. And yet, in light of the submissions she did make, they take on some significance. It's not enough, even at jurisdiction stage, just to point to an alleged differential effect and then ask the court to indulge in speculation to fill the, as Azerbaijan likes to call it, something more. Now, Professor Boisson de Chazourne made a point on permissible inferences based on the court's recent judgments on the merits in the first Ukraine versus Russia case. There, citing the Corfu Channel case, the court stated that, I quote, "A state that is not in a position to provide direct proof of certain facts should be allowed a more liberal recourse to inferences of fact and circumstantial evidence." In that case, the more liberal recourse was because of Ukraine's lack of access to evidence in Crimea. Counsel for Azerbaijan sought to draw an analogy between that situation and what she said was Azerbaijan's lack of access at the time of filing its memorial to the so-called occupied territories. But there is no analogy for 2 reasons. Firstly, the Ukraine case was dealing with the proof of facts at the merits stage. Azerbaijan doesn't need to prove facts at jurisdiction stage because Armenia must, and does, accept its factual allegations as true. So the issue of proof, and consequently of inferences, liberal or otherwise, doesn't arise. Secondly, in any event, on Azerbaijan's case, most of the environmental harm occurred in the 7 districts over which it has had control since the conclusion of the Second Nagorno-Karabakh War in late 2020. And indeed, it commissioned its own experts, industrial economics, who went to the, quote, formerly occupied area in 2021, although, as Armenia sets out in its preliminary objections, the resulting report takes Azerbaijan's discrimination case no further forward and, in fact, undermines it in a number of respects. Moving on then to the facts, you'll recall that Armenia took some time on Monday to work through the structure of Azerbaijan's case. Having heard Azerbaijan yesterday, it does not seem to be in dispute that on Azerbaijan's case, firstly, all the harm allegedly occurred in the 3 decades in which it describes Armenia as having occupied the territory. Second, Armenia controlled the relevant area. Third, ethnic Armenians lived in that area. Fourth, ethnic Azerbaijanis did not live in that area. One thing that Azerbaijan seems to have become confused about, however, is its own factual case about Armenia's intentions. You'll recall that on Monday I referred you to passages of Azerbaijan's memorial where its case is set out very clearly. It speaks of Armenia, quote, violating CERD by preventing Azerbaijanis from accessing those territories throughout the entire course of its almost 30-year occupation. How was this done? Well, Azerbaijan goes on to allege that, And we see on screen the armed forces of Armenia, including its installed regime, sealed off the then occupied territories from the rest of Azerbaijan using, and we see the military means described there, to reinforce the message that Azerbaijanis could never return to those territories. Azerbaijan's agent yesterday said that, quote, Armenia's council made the extraordinary and extremely misleading submission that Azerbaijanis had no intention of returning to those territories. He then gave a one-sided description of the process of negotiations as to a potential resolution of the situation. But it's abundantly clear that the submissions to which he took exception, including the passage he footnotes, were summarising Azerbaijan's own case as to Armenia's intentions, namely that, again according to Azerbaijan, Armenia did not intend the Azerbaijanis to return to the area. You've just seen that case set out clearly on the screen. Armenia, says Azerbaijan, was determined to use military means, quote, to reinforce the message that Azerbaijanis could never return to those territories. So when Azerbaijan's agent finds it, quote, puzzling that Armenia did not expect Azerbaijanis to return to the areas Armenia intentionally pillaged, unfortunately that puzzlement arises from Azerbaijan's own pleadings, on which its case on jurisdiction ratione materiae must stand or fall. To be sure, the case pleaded by Azerbaijan on this issue is not a remotely fair or accurate characterization of Armenia's actual intentions towards the many persons, Armenian and Azerbaijani, who had been displaced by the First Nagorno-Karabakh War. If this part of the case went to the merits, Armenia would have abundant evidence to show you about its good faith engagement in the Minsk process, through which Armenia strongly hoped to reach a resolution allowing return of all those who were displaced by the conflict. But at jurisdiction stage, Armenia has scrupulously taken Azerbaijan's factual allegations as true, and Azerbaijan must, of course, do the same. Turning to the legal requirements that Azerbaijan has to meet, Council yesterday did not address the first argument put forward by Armenia, namely that the acts and omissions it complains of were not capable of amounting to a differentiation of treatment of human beings. Moving on to the requirement that the conduct in question be based on a prohibited ground, which Azerbaijan did address, its submissions focused on what it says to have been different treatment of the 7 so-called occupied districts which had previously been populated by Azerbaijanis when compared with the territory which was occupied by ethnic Armenians. This alleged difference, or as Azerbaijan put it in the memorial, the purposeful concentration of environmental harm, is central to Azerbaijan's case at every stage of the discrimination analysis. And you'll recall that to make its case on this point, Council for Azerbaijan showed you a map. Council then noted that the yellow areas were formerly Azerbaijani, while the areas outlined in purple were those inhabited by people of Armenian origin. And she boldly claimed that there were no acts of environmental destruction in these purple areas. We can see, though, that this is contradicted by the map itself, which plainly shows alleged environmental harms in the purple areas too. Then when it comes to Armenia's case, Council for Azerbaijan claimed that Armenia's position is that the environmental harm was evenly distributed throughout the occupied territories. One searches in vain, though, for a footnote to point us to such a submission, written or oral, by Armenia. On the contrary, as you've seen, Armenia has been scrupulous to accept, at jurisdiction stage, Azerbaijan's factual case about, as I put it on Monday, what was done and where. So let's look at the map. As you can see, it claims to depict 4 types of environmental harm: construction of hydropower, mining activities, forest harm, and agricultural abandonment. To take the example of hydropower, as you see to the left, The hydroelectric stations are built in Kalbajar and Lachen districts, which are also, according to Azerbaijan's own experts, the districts with the highest levels of precipitation. As you see to the right, the Tartar, Hakkari, and Agavno rivers also run through these districts. And as you can see when we overlay the two maps, the hydropower plants allegedly constructed closely follow the flow of these rivers. Now, is Azerbaijan's case that these rivers flow in a discriminatory manner, or that the rain in Nagorno-Karabakh falls in a discriminatory way? Turning to mining activities, on Azerbaijan's map, these took place throughout what it calls the liberated territories, including in areas that were allegedly populated by ethnic Armenians, ringed here in dark blue. Unsurprisingly, areas where Azerbaijan alleges that there were mining activities are also the areas with large mineral reserves. In particular, Zangilan, ringed in red at the bottom, has gold, copper, faced stone, limestone and building stone, while Lachen, ringed to the left, and Kalbajar, ringed in green at the top left, have large chromite and mercury deposits. And so, to state the obvious, mines can only be built where the deposits are. Again, the argument cannot surely be that the mineral resources were distributed in a discriminatory fashion. Azerbaijan's claim that the, quote, abandonment of agricultural land constitutes differential treatment is similarly illogical. And we can see this from the report that Azerbaijan cited yesterday, which it calls a report of the UN Environment Programme. At the outset, we note that the report explicitly states that it, quote, does not constitute an official publication, and that the views expressed in it do not necessarily reflect the view of the United Nations Environment Programme. Elsewhere, the report notes that its findings were restricted not only by the objectives pursued by the government of Azerbaijan, but also by the fact that the sites visited were specifically selected by the government. In any event, on the farming issue, the report does not help Azerbaijan at all, since it makes clear that underfarming is due to depopulation because of the conflict. Interestingly, the report even notes that, quote, the resulting decline in agricultural activity may have inadvertently supported some ecological benefits in terms of ecosystem services and biodiversity. And again, we ask, is not farming agricultural land in a depopulated war zone really capable of being racial discrimination? Interestingly also, the same report makes clear that Azerbaijan has itself caused significant damage to forests. So we see new road construction, launched as part of the reconstruction drive in January 2021, is also having a significant impact on forest cover, particularly the approximately 80-kilometre highway segment between Fuzuli and Shusha. Council for Azerbaijan also relied on the 2016 resolution of the Parliamentary Assembly of the Council of Europe, but did not address the key points I made about this on Monday, including, firstly, the fact that the reservoir, which is located in Nagorno-Karabakh and which was damaged in the First Nagorno-Karabakh War, supplied water to the ethnic Armenian population of Nagorno-Karabakh as well as people downstream in Azerbaijan. Secondly, that the war damage meant that, quote, water from the Sarsang reservoir cannot be used for irrigation by anyone until the canal has been repaired. And thirdly, that the resolution characterises the alleged mismanagement of the reservoir as a tool of political influence. So we are no further forward in understanding how Armenia is said to have discriminated against Azerbaijan in this regard, or Azerbaijanis in this regard, when ethnic Armenians needed the water just as much. As I discussed on Monday, the overall case that Azerbaijan makes here is the purposeful concentration argument, or as Council put it yesterday, the idea that environmental harm was deliberately concentrated in areas formerly populated by Azerbaijanis. But after yesterday's submissions, the court still has no sense of why this is more than just secondary or collateral effects, if even that, given that on Azerbaijan's case, nobody lived in those areas. Azerbaijan has offered you no basis at all to conclude that there was any racial discrimination involved in, for example, situating hydroelectric power activity in areas where there was water, or mining in areas where there were the resources to mine. And as to how the Azerbaijani population could be discriminated against when they were not there to experience any of the impacts of this alleged activity, Azerbaijan falls back on the argument that the alleged environmental harm was all part of a campaign of ethnic cleansing. The ethnic cleansing allegation is doing a lot of work here. Counsel argued that Armenia's alleged ethnic cleansing was intended to ensure that Azerbaijanis would be deprived upon their return of their right to enjoy their homeland, including the environment and natural resources that form part of it. The problem with that is that the whole point of ethnic cleansing is that the perpetrator doesn't intend the displaced population to return. And as you've seen, that's exactly Azerbaijan's pleaded case on the facts and the law. Turning briefly to the various specific rights which Azerbaijan invokes in support of its claims, Professor Boisson de Chazourne stated yesterday that Armenia argues that the rights of health and property do not fall within the scope of the CERD. That is, of course, not Armenia's position. Its position is rather that Azerbaijan's case does not fall within the scope of those rights. And we saw yesterday how loosely they're being invoked. This includes the assertion that the destruction of the environment, whether intentional or not, has repercussions on the health and well-being of individuals and their fundamental rights. Now, that may be unobjectionable as an abstract statement, but the idea of unintentional harm being the basis for a CERD claim is rather difficult to understand, given, among other things, the requirement that the relevant acts be based on a protected characteristic. In this regard, Counsel for Azerbaijan did not engage with the points I made on Monday about, firstly, Azerbaijan's inaccurate presentation of the Western Shoshone case, secondly, the complete absence of any reference in the work of the CERD committee to the alleged right to return to a healthy environment, thirdly, the fact that the legal sources on property rights cited by Azerbaijan relate to the collective land rights of indigenous, tribal or minority communities, and one recommendation of the CERD Committee on racial discrimination against people of African descent. And Azerbaijan still, rightly, stops short of claiming that the former Azerbaijani population of the so-called occupied territories falls into any of these categories, despite gesturing in this general direction by referring to what it describes as the cultural importance of the territories in question. Instead of responding to these points, Azerbaijan made a series of scattershot references to general principles contained in instruments such as the Rio Declaration on Environment and Development and General Comment number 14 of the Committee on Economic, Social and Cultural Rights. But again, none of these general statements of principle gives Azerbaijan the slightest assistance in establishing the complex blend of rights that it now seeks to rely on. And so its case also fails, we say, for lack of the engagement of any specific rights in the contorted factual situation which forms the basis of its discrimination claim. In conclusion, Mr. President, members of the Court, Armenia submits that nothing you heard yesterday helps Azerbaijan to establish its claim of racial discrimination. So Armenia respectfully asks you to uphold its jurisdictional objection in this regard. Mr. President, that concludes my submissions. I thank you for your attention, and I ask you to call upon the agent of Armenia, His Excellency Mr. Kyriakosyan, to present Armenia's final submissions.
I thank Ms. MacDonald for her statement. I now invite the agent of Armenia, His Excellency Mr. Kyriakosyan, to take the floor. You have the floor, Excellency.
Thank you. Thank you. Mr. President,
Madam Vice President, distinguished members of the Court, thank you once again for your kind attention throughout the course of the Armenia's submissions. Council showed that Armenia's preliminary objections are well properly before you, and we look forward to Court's judgment. Before reading Armenia's final submissions, I would like, however, to make 4 brief points responding to some of the allegations made against Armenia in the course of Azerbaijan's opening submissions yesterday. These allegations are not the proper province of this phase. The same holds true for our responses, but with the Court's indulgence, I will raise them now for the record. First, Azerbaijan's agent referred yesterday to nearly 100-year-old statements claiming that Armenia has endorsed racist ideologies. Let me be clear. The author of those statements, Garagin Nezhde, is a prominent figure in Armenian history. He is known for his role as a military leader and statesman, and is widely credited, among other things, for playing a key role in preventing the severing of the Sunnic region of Armenia during 1920-21, as well as for defending Armenian people following the Armenian genocide, which the world commemorates today and Azerbaijan denies. He is not, however, venerated for the statements Azerbaijan placed on the screen yesterday. Azerbaijan's agent also showed images of what he called a parade, which allegedly, and I quote, ended in collective Nazi salute in front of the statue of Garagin Nezhde. But as is clear from Azerbaijan's own slides, the so-called parade was attended by fewer than 15 individuals. And it should not be surprising that fringe groups occasionally abuse freedom of expression in a democratic society. Armenia is no different from any other democratic society in that regard. It is not long ago that Azerbaijan sought to convince you that freedom of expression in Azerbaijan could only be exercised in the Lachin corridor. And my hope is that the irony is lost on the Court. Azerbaijan's agent further referred to a statement by Twitter asserting that it had removed 33 accounts that had been tied to the government of Armenia. The members of the Court will recall that in its first request for provisional measures, Azerbaijan relied on the same statement to request the Court order Armenia to, and I quote, cease and desist incitement based on the fabrication of public and private hate speech attributed to Azerbaijanis on Twitter and other social media and traditional media channels, end of quote. But the Court declined to make such an order, and while Azerbaijan is free to seek to revive that unfounded argument on the merits, Armenia will once again address it at that stage. The second point I wish to address concerns Azerbaijan's criticism of my statement on Monday denying that Armenia ever illegally occupied Azerbaijan's territory or controlled the authorities in Nagorno-Karabakh. According to Azerbaijan's agent, Armenia, and I quote, ignores the overwhelming response of the international community to Armenia's invasion and occupation, which rejected Armenia's conveniently created self-determination narrative, end of quote. Azerbaijan places much emphasis on the European Court of Human Rights judgment in Shiragov case, which determined that Armenia had jurisdiction under Article 1 of the European Convention over Nagorno-Karabakh. Azerbaijan, however, glosses over the fact that the court's jurisdictional determination, in the court's own words, has never been equated with the test for establishing a state's responsibility for an internationally wrongful act. To be clear, the European Court has never found Armenia to have occupied Nagorno-Karabakh. Nor did any of the UN Security Council resolutions relating to the Nagorno-Karabakh conflict the agent and counsel for Azerbaijan misrepresented yesterday. The Security Council has called on Armenia to, and I quote, continue to exert its influence to achieve compliance by Armenians of Nagorno-Karabakh, but has never referred to Armenia as an occupying power, let alone an aggressor. It instead referred to the local Armenian forces of Nagorno-Karabakh as the occupying forces and urged the parties, and I quote, immediately resume negotiations for the resolution of the conflict within the framework of the peace process of the Minsk Group, end of quote. That is exactly what Armenia and the authorities of Nagorno-Karabakh did. Azerbaijan, in contrast, unilaterally decided, in President Aliyev's own words, that, quote, war was inevitable and that, quote, Minsk Group was dead, end of quote. And it was Azerbaijan that, again, in President Aliyev's words, then started the Second Nagorno-Karabakh War, which Azerbaijan's agent did not dare to deny yesterday. This brings me to the third point I wish to make. Azerbaijan's agent accused Armenia's counsel yesterday of having misleadingly submitted that Azerbaijan is never intended to return to the so-called formerly occupied territories. As Ms. MacDonald has explained, that is decidedly not what Armenia's counsel said. In any event, like the Minsk Group co-chairs, and Armenia has always been committed to the reciprocal return of refugees. And Armenia agrees with Azerbaijan's agents that their return was a crucial component of any negotiations. But as I have already noted, it was Azerbaijan that abandoned the Minsk Group co-chairs negotiation format. Moreover, the basic principles proposed by the Minsk Group's co-chairs did not just call for reciprocal return of refugees and return of the territories surrounding Nagorno-Karabakh to Azerbaijani control. The two bullets from the basic principle that Azerbaijan selectively highlighted on your screens, they also called for an interim status for Nagorno-Karabakh, providing guarantees for security and self-governance, a corridor linking Armenia to Nagorno-Karabakh, the future determination of the final legal status of Nagorno-Karabakh through a legally binding expression of will, and international security guarantees that would include a peacekeeping operation. In addition, the co-chairs explicitly based their basic principles on, among others, the principle of, quote, equal rights and self-determination of peoples, end of quote. In such circumstances, it is difficult to see how Azerbaijan's agent could bring himself to claim before this court that the international community, and I quote, rejected Armenia's conveniently created self-determination narrative, end of quote. My fourth and final point relates to Azerbaijan's agent's assertion that during the course of so-called occupation, Armenia, and I quote, prevented access by Azerbaijan, UN agencies and other international organizations as a means of precluding Azerbaijan from complaining about Armenia's racist occupation campaign following liberation of its territories, end of quote. As Azerbaijan knows, however, neither Armenia nor the local representatives in Nagorno-Karabakh ever prevented the UN from accessing Nagorno-Karabakh. And Azerbaijan's agent conspicuously cited nothing in support of his statement asserting that they did. In reality, it was Azerbaijan that impeded UN access, and it is Azerbaijan that continues to do so today. It was also Azerbaijan that repeatedly refused to cooperate with the ethnic Armenians of Nagorno-Karabakh, including with respect to issues of environmental protection and the Sarsang reservoir. I will now read Armenia's final submissions. The Republic of Armenia respectfully requests the Court to A. Uphold the preliminary objections raised by the Republic of Armenia concerning the jurisdiction ratione temporis of the Court, and adjudge and declare that it lacks jurisdiction with respect to Azerbaijan's claims and contentions concerning events that transpired prior to the entry into force of the CERT as between the parties on 15 September 1996. B. In the alternative, uphold the preliminary objection raised by the Republic of Armenia concerning the admissibility of the claims, and adjudge and declare that Azerbaijan's claims and contentions concerning events that transpired prior to the entry into force of the CERT as between the parties on 15 September 1996 are inadmissible. C. Uphold the preliminary objection raised by the Republic of Armenia concerning the jurisdiction ratione materia of the Court, and adjudge and declare that it lacks jurisdiction with respect to Azerbaijan's claims and contentions concerning the alleged placement of landmines and booby traps. And D. Uphold the preliminary objection raised by the Republic of Armenia concerning the jurisdiction of ratione materia of the Court, and adjudge and declare that it lacks jurisdiction with respect to Azerbaijan's claims and contentions concerning alleged environmental harm. Mr. President, members of the Court, this concludes Armenia's submissions on its preliminary objections. With your kind indulgence, I wish only to thank the interpreters and the registry for their professional assistance throughout these proceedings. And of course, thank you, members of the Court, for your kind attention.
I thank His Excellency Mr. Karagozian. La Cour prend note des conclusions finales.
The Court takes note of your final submissions, which you have just read on behalf of Your Excellency's government. The Court will meet again on Friday, the 26th of April at 10 a.m. to hear the second round of oral argument of Azerbaijan. The sitting is adjourned.